Being in a car accident, it's just completely overwhelming, right? And what comes next can feel even more complicated. So, in this explainer, we're going to cut through all that confusion and give you a really clear, step-by-step guide to making a compensation claim here in Scotland.
Let's be honest, in those first few moments after a crash, you're dealing with shock, maybe some adrenaline, a lot of stress. The idea of some kind of legal claim feels a million miles away. It's probably the absolute last thing on your mind.
But here's the thing you need to know. There's actually a really clear, well-worn path to follow. It's a process that's been established for a long time, and with the right support, it's definitely something you can manage.
Okay, so let's jump right in. Here's the roadmap for this explainer. We're going to cover the immediate aftermath, how to actually start your claim, what goes into building your case, how you get to a settlement, and finally, the really important safeguards, including one deadline you absolutely cannot miss. Right, first things first, let's start right where it all begins, at the scene of the accident. Believe me, what you do in these first few hours can be absolutely critical for everything that follows.
Now, this slide gives you 5 really simple things you can do that will make a massive difference down the line. Number 1, obviously make sure everyone is safe. 2, exchange details with the other driver. Names, insurance, the basics. 3, and this is a big one, take photos of everything. Your phone is your best friend here. Get pics of the cars, the damage, the road layout. 4, if anyone saw what happened, try to get their name and number. And 5, if anyone has been injured, you must report the accident to the police.
Okay, now this next point is so important, please listen up. It can be a totally natural reaction to say, "Oh, I'm so sorry." But you have to avoid admitting fault at the scene. You're not a legal expert, and the situation might be more complex than it seems. Just stick to the facts of what happened.
So, you've left the scene. What's next? You need to see a doctor as soon as you can, even if you think your injuries are minor. Things like whiplash can take a few days to really show up. And here's why it's so important. A prompt medical visit creates an official record, a piece of evidence that directly links your injuries to that accident. It's a cornerstone of your whole claim.
All right, so you've handled the immediate chaos. Let's move on and see how we get the official process started. It's time to get the wheels turning on the formal claim itself.
So you have to tell your own insurance company about the accident. It's just a standard part of your policy. But, and this is the bit people get confused about, you are simply reporting the incident. You are not making a claim on your own policy. Your claim for your injuries will actually go against the other driver's insurance. It's a really important distinction.
Now, I know what you're probably thinking. How can I afford a lawyer? Well, in Scotland, personal injury claims are almost always handled on what's called a no-win, no-fee basis. It's exactly what it sounds like. You pay nothing up front to get started, and if you win, your solicitor gets their fees from the other side. So for you, there's no financial risk at all.
Right, so you've got a solicitor on your side. What happens next? Well, now it's all about building a rock-solid case. Their first job is to let the other side know a claim is coming, and then the evidence gathering begins.
This right here is the first major fork in the road. Your solicitor sends out an official notification, and the other driver's insurer has to respond. They'll either admit their driver was at fault, or they'll deny it, and their answer changes everything. If they admit it, the case is all about figuring out compensation. If they deny it, then we have to focus on proving who was actually responsible for the crash.
And this slide lays it out perfectly. Your solicitor is basically gathering evidence on 2 parallel tracks. On one side, you've got the medical evidence, your GP records, hospital notes, and usually an independent expert report to map out your injuries. And on the other side, there's the financial evidence, calculating every single loss, from lost wages and physiotherapy costs to bus fares for hospital appointments.
So once all that evidence is pulled together, the process moves into the negotiation phase. This is where we start talking about turning all that proof and paperwork into a financial settlement.
And this part usually follows a pretty straightforward path. First, your solicitor sends a formal letter of claim, which basically lays out your entire case and how much you're claiming. Then, a period of back-and-forth negotiation starts. And finally, once a figure is agreed upon, the settlement gets paid. And listen, this is a huge point to wrap your head around. Once you accept an offer, that's it. It's final. The case is closed forever. You can't go back in a year and say, actually, my back is worse than I thought. This is exactly why a good solicitor will always tell you not to settle until your long-term medical outlook, your prognosis, is crystal clear.
So what happens if they just won't make a fair offer? What if you're at a stalemate? And more importantly, what's that one massive deadline looming over this whole thing that you just cannot ignore?
Now, if the insurance company is being unreasonable, your solicitor can raise court proceedings. And I know that sounds scary, but hold on. It almost never means you'll actually see the inside of a courtroom. It's more of a legal tool. In fact, taking this formal step is often the very thing that makes the other side get serious about negotiating, and most cases settle very quickly after this.
But through all of this, there's a clock ticking in the background, a really, really important one. It's the one thing that governs your fundamental right to even make a claim. Any ideas what the single most critical deadline in this whole process is?
3 years. That's the magic number. You have exactly 3 years from the date of the accident to either settle your claim or to formally raise those court proceedings we just talked about.
And this timeline shows you exactly what that means. If you let that 3-year window close without taking action, your claim is gone, vanished, forever. In nearly every case, it's what we call time-barred. It is an absolute final deadline, which is why getting legal advice early on is so important.
All right, so let's do a super quick recap. The process? It's just a series of logical steps. What you do right at the scene, and seeing a doctor early on, absolutely vital. A specialist solicitor is your guide through the whole thing, and that 3-year time limit, well, it's non-negotiable.
You know, the whole system is really designed to get you to a fair outcome, to put you back in the position you were in before the accident. And it makes you wonder, doesn't it? In a long journey like this, with all these different stages, is the hardest part and the most important part simply taking that very first step? Making that first call for advice that gets the whole ball rolling?